Hello everyone, Plaintiffs Attorney Jonathan Hilton here, and I am here to talk to you today about Brief Writing 101 for Plaintiffs Attorneys. It is a subject that I am very passionate about. Quick intro to who we are. This is me over here on the right. This is Jeff Parker here on the left. We are plaintiffs attorneys who write briefs for other plaintiffs attorneys. So we provide bespoke briefs for your most challenging legal issues. Okay. Brief Writing 101, a thought to get started. I'm not going to start with you sitting at your desk. I'm going to start with the judge in her chambers or in his chambers, and even the law clerk who's there reading the briefs. How busy is this person? And what I want to translate that into is how much does this person care already about your case when they get the brief? Okay, how busy are judges? Well, in state court, it's absolutely insane. At least in federal court, it's only moderately insane. So federally, there are 670 judges, more or less, at the district court level, at the lower court level. And there's about 250,000 new cases per year. Now, occasionally that number goes up to 400,000. If it's hitting that number, it usually has to do with something. It has something to do with some multi-district litigation that's been filed, and hopefully that isn't creating as much work for these judges because it's all going to go more or less to one judge. But that being said, if you're looking at the 250,000 number, that's roughly 300 new cases per year per judge. Now, certainly some of those are going to settle without court involvement, but you get the picture. You have a judge who, if in a third of these cases a motion to dismiss is filed, that's 100 motions to dismiss per year. So these judges are busy. Brings me to the next question. What does this mean? Well, I think over the years what we've seen is that the busier the court gets, the harder it is for you as a plaintiff's attorney to survive a motion to dismiss or a motion for summary judgment. Okay, well, why is that? Well, it's because courts are tightening the belt. Back in the old days, there was notice pleading. Notice pleading at the federal level used to mean that if you were filing a complaint, you didn't even have to include facts that clearly spelled out how you were going to win on each element of your claim. So you could put forward your theories. Maybe, for instance, you could say, well, this defendant was in a partnership with this other defendant, and that's why they're both liable. But you didn't have to go through and spell out like all the elements of the partnership while they share profits and revenues and and they have this agreement and so on. You just say, yeah, they're, on information and belief, they're partners. Not so true anymore. So we've moved, and this is something, it's a judicial shift. It's not due to any legislation by Congress. It is purely because judges are tightening the belt. The Supreme Court is tightening the belt, trying to rein in litigation that, as they see it, has gotten out of control. You used to have this standard. You could go in on a motion to dismiss, and the defendant had to basically show it was impossible for you to win your case. No set of facts. That was the old standard, Conley versus Gibson. Now it's a plausibility standard. What does that mean? Well, the Supreme Court has provided guidance to judges that if in their judicial experience and common sense, you have not put forward a claim, basically if they think your allegations in their experience based on their own background and their own background knowledge, if they think it's implausible, it's going out the window. So that means even at the pleading stage, you've got to put in a lot more facts to try to persuade the judge that you know what you're talking about and you know how you're going to win and how you're going to get there. So all brings it back. Who are you really fighting on a motion to dismiss? Everybody thinks, oh, well, I'm up against the other guy. I'm up against the person or the company who has filed this motion to dismiss. I want to put a different perspective in your head. Anytime that you have a motion or a brief in front of the court, there's an implied war going on where you are fighting with the other litigants for the judge's time. There are only so many judges, okay? And there are so many motions filed. So your job is not necessarily to beat down the other person's motion to dismiss or their motion for summary judgment. If you're the plaintiff, your job is to show the judge that your plaintiff is worthy of the court's time and attention. Your plaintiff is worthy of a trial. There's a real injury here. So you have to find a way to present that compelling story. And in my experience, being able to tell your client's story in a way that makes the judge want to open those doors of justice for your client, that is way more meaningful than just showing that you did better research than the other side or trying to point out some technicality or flaw. Okay, so how do we bring this into our brief writing? Well, I'm going to give you two guiding principles that I think it should govern all brief writing, almost all of it, but I think it's especially important for plaintiffs. The first guiding principle is that you have to make sure that the judge will, at every moment, actually want your client to have access to justice. With those new pleading standards over the years, the Supreme Court has even used the phrase that they don't want plaintiffs to be able to automatically, just by filing a complaint, unlock the doors of discovery. That's what they're talking about. They don't want to give you and your plaintiffs access to discovery, to the court's time, to the defendant's resources. They want to keep those doors shut to all but worthy plaintiffs. So that's principle number one, is that you have to make sure that the judge wants your plaintiff to succeed. Now, of course, they remain impartial, but you have to show that you are worth a shot. Your plaintiff's case is worth a shot, and you deserve that day in court. Guiding principle number two, though, and this is the flip side of it, you have to show the judge that you're going to minimize the burden on the court's time. Okay? So you have to have a worthy plaintiff on the one hand, and then you also have to be able to show that affording this plaintiff justice is not going to drain so much of the court's energy and time and resources hunting around, trying to figure out what your arguments are. You don't want to ever put the judge in the position of having to make the arguments for you. You have to make everything crystal clear to the court. So those two things, if you can show those two things, you're going to succeed on so many briefs and in so many motions, because you're showing the court that from a practical standpoint, this is a case that they should let proceed. Okay. I think these rules shape everything. Today in this lecture, we're going to talk about that principle number two, because I think people just neglect that one, which is saving the judge's time. And if you get those points right, even if you have a client who's not particularly sympathetic, or you have a case that might not be the best, you at least have a shot, because you're not draining everyone's resources as the case moves forward, and you're being clear about what you want and why your case should go up there. So I'm going to build those skills with you first, and then we're going to get into the likability of your plaintiff, or what I call likability, which is getting to the actual persuasion, trying to persuade that judge to take your side. So I'm just going to minimize this a little bit here so that you can see the 10 tips that we're going to go through. And today is going to be about the first 5. Saving time, having a clean layout, putting everything that the judge needs to rule in your favor up front, cutting the garbage, so cutting down on your string cites, cutting down on anything that's going to tend to balloon in your brief and take up that prime real estate, and then doing the work in the headings. You're going to have, your argument heading, you're going to have A, B, C, and D, however it is. You need to connect all the dots for the judge in your headings. That way, you're saving the judge's time, and they know what you're arguing before they even sit down to really read your argument. And then tip number 5, cutting bad arguments. This is going to be essential, because If you are bringing in any bad arguments, you are wasting the judge's time and you are diluting your good arguments. So you don't just throw in extra arguments thinking, wow, the more arguments I have, the more likely something is to stick. You cut those bad arguments so that you can focus the judge on what matters. So saving time, in a way, you can also conceptualize this as focusing the judge's attention on what matters. Okay, clean layout. What do I mean by this? You got to prove to the judge that your case is not a dumpster fire. This is so important in particularly discovery motions. You have to show the judge that this is not a dumpster fire. If you submit a 40-page brief, it's going to be a problem. You want to keep the issues narrow and clean, but you also just want to give the judge a clean look and feel. So think of it this way. You are a magazine editor, okay? You're not just a brief writer. You're an artist. You're a magazine editor, whatever it is. And you're trying to provide a product to the court that looks and feels nice, something that they want to read. Let's talk about white space. What is white space? So the white space in any magazine is basically going to be your margins here. And then you got a little bit of white space going on here. You got a little bit going on here. But basically by breaking up enough paragraphs, you're going to have white space. White space is something that really hit the magazine editor space back in the 90s and the 2000s as editors began to realize that more text is not what their readers wanted. Their readers wanted something that looked and felt clean. They liked a lot of images. They didn't want just a massive block page of text. And I remember when I was a teenager, I actually was a journalist writing for Chess Life magazine, of all things. And I had a wonderful editor who, if I turned in 1,800 words, he would say, yeah, but I want 700 words. And I'd say, why? We haven't reduced the number of pages. And he says, I want more white space. And it took me so long to get it, but it's so true. You have to have something that looks and feels clean, or else you're not setting the table for the reader to sit down and basically have a nice time in the land of your brief. So I just have a rule. Paragraphs really shouldn't be more than 7 lines. Why do I have this rule? Well, one is that it gives me more white space. 2 is that I think the paragraph just really looks unwieldy if you get it that big. But then 3, I want you to think about what happens when a judge or a law clerk is skimming your brief. Well, what do you do when you skim? Probably you read the headings, and then you read the first sentence of every paragraph. And that's why I call the first sentence of every paragraph, that is going to be some key real estate right there. And if you start new paragraphs frequently, you are improving the value of your real estate in this brief. The middle of paragraphs tends to get lost. The back end of a paragraph can be unwieldy as well. If it's a long back end of a paragraph, it's probably very low value real estate. If you want to pack a punch at the end of a paragraph and try to improve that real estate, you can do that. And what you want to do is narrow it down just in the last sentence. You want to have a very short sentence that packs a punch. So I want to walk you through this page and show you what I'm talking about. So I want you to imagine that you're a judge and you've just sat down to read this brief and you are skimming. Let's say that you just read the first sentence of every paragraph. It goes like this. This is a case arising from a decade-long dispute between Kenneth Armstrong, a Florida homeowner, and U.S. Bank, the company headquartered on nearby Walnut Street that holds Mr. Armstrong's note. Okay, now I'm going to cut down immediately to the next paragraph. Following the 2019 bench trial, Mr. Armstrong, wanting some certainty in his life, sued here in Hamilton County and sought a declaration that the statute of limitations had run on the note. Let's skip the rest and move down to the next one. U.S. Bank waited over a year to challenge the default. Okay, so even if the reader is skipping the back ends of the paragraphs, you've still built a lot of the story in, and the judge is still getting the basic picture. You got some guy in Florida. He probably got sued by U.S. Bank in Florida, and he won. He sued U.S. Bank here in Ohio for declaratory judgment, and you got a default judgment, and U.S. Bank waited a year to challenge it. You got most of everything in there just in those first sentences. It's not 100%, but it's 80%. The judge can fill in the gaps. Okay, so how do you improve the real estate on the back end of these paragraphs? I think the big thing is if you keep the last sentence very short, it's likely that the judge is still going to read it. You've got this here. You've got in the first paragraph, yet it still demands payment. Boom. Okay. It's short, it's punchy. You're at least maybe getting the judge involved. If it's a string cite on the back, you've probably lost them already. So clean layout, I think, is an example of a page that just has a nice clean layout. Okay, tip number 2. Front load, front load, front load. What do I mean by that? Okay, well, just like in a paragraph, the first sentence is what matters. The last sentence kind of matters if you make it punchy. And then the stuff in the middle tends to get glossed over. If you have a 30-page brief, the first 5 pages are what matters. People make up their minds so fast. And yes, judges have a unique ability to remain impartial, and yes, they're going to try to stay with you. But if you've lost most of the battle in the first 5 pages by not getting to the point and explaining to the judge why you should be allowed to have this lawsuit in court, if you just haven't gotten there in the first 30 seconds, you're fighting an uphill battle the rest of the way. I mean, there is just an increase across the board in courts granting motions to dismiss since Twombly and Iqbal. And summary judgment, again, over the last few hundred years, as the courts have gotten busier, it's used more and more. So it's almost like you're fighting uphill from the beginning, and because you've got to prove, all of these elements, you got to surmount all these hurdles. If you're not convincing the judge in the first few seconds that your case is worth something, then you're going to be fighting uphill the rest of the way. So my rule is put everything that you need in order to win in your introduction. You can call it introduction and summary of argument. Always include a summary of argument. Even if it's just a short motion and it's the first few paragraphs on the first page, that's fine. But you need to get everything in there that you need the judge to know in order to rule in your favor. So all your best facts go in there. You need to create a roadmap to victory. The judge needs to understand, okay, I could rule for you on point A and B, or I could rule for you on point C and D, and you still survive. So you need to be creating that roadmap of how you're going to get there. You need to be plugging in the facts to the law. And it's okay if the intro is long, because let me tell you something. When somebody picks up a brief, let's say that they don't have a ton of time, what do they tell themselves they're going to do? Well, I'm waiting on my Uber, or I'm waiting on my coffee, or I'm waiting on the microwave. I don't have time to read this whole brief, but let's just read the intro and get a flavor. Okay, so if your intro is 5 pages long rather than 3 pages long, probably you're still getting them to come with you on that journey for the first 5 pages because they told themselves when they sat down, I'm just going to read the intro. So I like to keep it. I have what I call the microwave rule, which is 5 minutes. You want to time it, get your buddy to read it, get somebody, your colleague, your mom, I don't care. Get somebody to read it and just time out, okay, how long more or less is that 5 minutes? And in that 5 minutes, you need to find a way to get everything in there that you need in order to win. And really, that's all the time you get. Okay, I've mentioned this before. Think of your brief as real estate. You're going to have, just like in Monopoly, you're going to have your high-priced rents, your boardwalk real estate. That's going to be the very first paragraph when the judge sits down. And then after that, I think the headings, because the judge is going to skim through the headings. They've got the brief open. What are they going to do? They're going to go through, they're going to flip through, and they're going to read all the headings. So if you do the work in those parts of the brief, you're going to have a lot better results because the judges are going to understand your arguments sooner. I want you to think of every brief as a race with the other side to try to make sense of the case. The judge is going to read their brief, the judge is going to read your brief. Whichever brief makes sense to that judge first is what's going to start clicking in their head. And it's going to give them that little shot of dopamine, it's going to keep them moving through and accepting your arguments and nodding along. Okay, so the first paragraph of your brief is big real estate. Your headings are big real estate. Other high value real estate, your introductions, and then the first sentences of your paragraphs. And what I call the areas that probably need some upgrades in your briefs, the back ends of paragraphs. And you can do that by keeping them short or punchy, like I showed you earlier. And then your conclusions, because let's face it, the judge gets to the conclusion, they just think, they're already smelling lunch when they get to your conclusion because they see the word conclusion. They're expecting you to just give something formulaic like, for all the aforementioned reasons mentioned above, plaintiff hereby requests that defendant's motion to dismiss be denied, not, and then the signature. They're expecting that. If you give them a little bit of a punch instead, something that's interesting, something that reminds them of some important point in the case that you want them to focus in on, that's an area of your brief that you can upgrade. And we'll get to that later. But for now, you should be thinking about briefs in terms of real estate and trying to get the most bang for your buck. Okay, string cites. Let's get to string cites because everybody likes to cake on 20 cases showing that they are right. Okay, that's not conserving space and that's not conserving your prime real estate. So this is an example. You can see, this is like a third of a page at least. Actually, maybe it's about half a page. You got one little case up here, you got one case here, another case, another case, another case. What point was the author trying to make here? The point the author was trying to make is that a party can waive an argument in the trial court. They can waive an argument on appeal if they didn't make it in the trial court. Okay, I mean, surely there's something packed in there, but why do you need this many cases to prove that point, really? And the point is you don't. This is my response to that string cite. I did include a couple of cases, but to get to the waiver point, the way that you handle a person who's writing in string cites is to come back and write something that's in English. People read plain English. So the way that I handled it in this case was to just use English and explain when can the court consider a party's argument. So they argue waiver, but they have this big string cite, and then I just use natural flowing words, English, just trying to get it without including some big string cite. So I do have to put in some authority because they put in a lot of authority, but I limit it to 2. You really want to limit it. If you got a string cite, like 2 cases is enough. If there's one case that stands for a proposition, you have a case. 2 cases if you really feel like you need to combat something, but more than 2, nobody's looking at this. People have skipped on to the next thing. So I'm hoping that we don't see too many string cites. Let's talk about some more of the rationale, though, because I know I didn't persuade you yet to stop string citing. Okay? Here's what I'm proposing that you do instead. If you have 5 cases that stand for a proposition, I want you to actually go and read them all. And I want you to do the work for the judge and think about which of those cases do you actually want the judge to read. If you cite one case, there's a good chance that the judge or the law clerk will actually go read it. If there's a case in there that you think is going to put the judge in a mood to rule for you or can help show your arguments in a good light, that's what you got to go do. You got to do that. But if you put in 5 cases, the judge is probably not going to read any of them. Just an important point, like, how does a judge see herself? The judge doesn't think of herself as a mere bean counter going in and saying, well, this side cited 19 cases and this side only cited 14 cases. The 19 cases have it. That's not what they view themselves as doing. And it's also not how humans work. Maybe in law school, that's how your brain works because you don't know any better. But when you get out in the real world, judges are trying to make rulings that make sense and that do justice. If you have one case that you explain really well and that really supports your side and it's well reasoned, and anybody who reads it will recognize that it's a well reasoned case, you can face down opposition that just string cites 10 cases because the judge is looking at the quality of the opinions, not the quantity. I mean, there are going to be some exceptions to that. I think that the exception hits sometimes when you get like maybe above 20 cases and there's one case that goes a different way. There is going to be a tipping point somewhere in there. But at that level, you still, if you got a string cite for that reason, some of those cases have got to go in a footnote so that whatever you want to lead with your best soldier, put that person out front, and just drop a footnote and put the rest of the cases there so that the judge will actually go read the one case that it looks like you're citing. It shows your confidence. A brief that cites one case for a proposition and you just hit the nail on the head, you found like a really good case that says it, that shows the judge that you're confident. Maybe you could have gone and found more, but if you cite 2 cases and the second one isn't as good, all you're doing is diluting the quality of the first one. And if you throw 5 cases at the judge, what are you telling the judge? You're telling the judge, I have a feeling that the law maybe says X, and here's 5 cases that might support Proposition X, but I want you to go do the work and make sure for me, because I wasn't confident enough to tell you what the law is. So don't do that. Find one case, tell the judge what the law is. Confidence is so meaningful because you need, if the judge thinks that you don't believe your own argument, you're toast. Your job is to represent that plaintiff. And if you don't believe your argument, and you don't believe in that plaintiff, the judge is going to sense that weakness. And if you don't believe the case and you don't think that you're fighting for justice or you think that you're wrong, the judge is going to pick up on that and your case is not going to make it to trial one way or another. your case is not going to make it to trial. Okay, well, now that I've told you not to string cite, I'm going to give you an exception, which is sometimes if you're trying to get a court to accept a new legal theory or a new legal theory for that court, you do need to go ahead and give the judge the bean counter evidence and say, look, 5 other states have adopted this, or 2 other states have adopted this. But if you've got to do it, I want you to do something to ease the judge's pain. So let's do a little bit of a deep dive into this particular string cite from a case that I did. This is a case in front of the Nevada Supreme Court. So start with a lead-in. Okay, what I did in this, so to give you some background on this case, what I was trying to do here is get the court to accept a novel theory of pharmaceutical liability called innovator liability. Innovator liability is a doctrine, essentially, or a legal theory of liability that says that a name brand manufacturer can be held liable for harms caused by pills created by a generic because it is the manufacturer who writes the warning label, and the generic is simply required by federal law to copy it. So it's basically, you have this unique situation where the brand name manufacturer has to write what becomes the warning label for the generic. And if you have a plaintiff who is injured by the generic product and you want to go sue the brand name manufacturer for it, you got to use this new theory coming out called innovator liability. So here I'm trying to convince a court to adopt that theory. So the first thing that I do is that I try to set up a dichotomy of, okay, here are cases that have gone the other way. I'm acknowledging that there's some bad authority. But I point out, okay, in those cases, there were state statutes on point that prevented the court from adopting innovator liability. And I let some of the citations do the work. I just put in here, okay, distinguishing such cases. So I have that done over here. But then I have the lead into my string cite, and I say, but where no statute requires otherwise, judges adopt innovator liability, allocating the risk of loss to the party in the best position to prevent the harm, the brand name manufacturer. Okay? So you have a good lead-in. You're telling the judge why you're giving them a string cite. You're not just saying, here's Proposition X and here's 10 cases. You're saying, I want you to look at a trend of how courts are ruling and what is the central theme that's uniting all of the cases in the string cite. Okay, you want to save space and you don't want to make it too painful. So if you've already talked about cases, I would omit parentheticals. So in this, my lead cases, I have short cites here because I've already discussed them elsewhere in the brief, and so I'm keeping it tight. But then here towards the end where I'm getting into other cases that I haven't yet explained or that might not be immediately obvious why I'm citing them, I go ahead and explain exactly what it is that I'm citing them for. Okay, by doing a lead-in and by looking at that parenthetical, I want you, again, we're talking about cleanliness in your brief, setting the table so that the judge wants to sit down and be in that space where they're reading the brief. I kid you not, I probably spent an hour juggling this, just trying to get this right so that it looks good and it feels good and it fits on one page and it's clean. So spend time cleaning it up. Really think about who needs a parenthetical, who doesn't, which case is going to need that parenthetical. And pro tip, if there's a case that goes out there and cites all of these cases, you might just consider saving all of the space and just cite that one case and then say collecting cases. I do that all the time. You want to keep the judge moving. You don't want to weigh the brief down with string cites if you don't need to. So that's just a good cheat if you need to get out of it. And if that case that collects the cases isn't the best one for you, you can pick the best one, put it first, and then just see also, put that other one collecting cases. If you really feel like you need that much authority. But chances are you probably don't. In most situations, one case is good enough. Okay, we're talking about conserving space, okay? This is a pet peeve of mine. Legal standards, like where you say, you have that section, it's called legal standard, and it says, on a motion to dismiss, the judge can consider this and this, and whatever it is that you want to put. People have developed these in firms, particularly, plaintiffs firms, defense firms. They've written these so many times that they've built them out. Anytime a new case comes out, they read it, and then they put it in. And so these things become like monsters. They're rolling downhill. They're collecting new cases and getting bigger and bigger and bigger. I have seen them span 2 pages. I've seen them span, in one case, 6 pages. The standard for a motion to eliminate, you get to 6 pages. Nobody's reading that. Nobody cares about that. All you've done is that you've made the judge skip down to try to find your argument, and you've wasted prime real estate. Legal standards tend to be towards the front of your argument. How could you waste that space? You're not making that up. That's not good. And everybody skips them because the judge knows the standard for summary judgment. I read a brief one time. The defendant just put, the court knows the standard for summary judgment. And then they just moved on. Okay, you don't have to do that, but you also don't need, you don't need an entire page. You shouldn't be taking an entire page on most things. So what do I want you to do? Well, I want you to pick a point that you think is relevant to your case, and I want you to hammer it. I want you to hammer it in the legal standards section. This is one I did. This one, I love this. And I do this kinds of thing all the time. I do, boom. I just put it in there. If there's one thing that I want to stress, I'm going to do legal standard. Plaintiffs get the benefit of all reasonable inferences. Wow. So I've just reminded the judge of that one point, and that's the only point that I hit. At the motion to dismiss stage, the court takes as true the complaint's factual allegations and gives the plaintiff the benefit of all reasonable inferences that can be drawn from them. And I do almost all of my legal standards that way on motions to dismiss. That's all I say. And there's some, whether it's Ninth Circuit or Sixth Circuit or wherever, you can find the case that says basically this. But why am I doing this? Well, I want to remind the judge, yes, everybody knows that you have to take my factual allegations as true, but I'm reminding the judge they have to go further than that. They have to give me reasonable inferences as well. And then in my argument section, I'm free to go out and draw inferences from the conduct that I've described in the complaint, draw inferences about the defendant's state of mind, draw inferences about whether they were involved in a partnership or conspiracy. That's what I'm free to do. But you should tailor this. You should think about where are you likely to lose, and you should be tailoring this legal standard section just to that. Okay, state court. Let's go into state court one because you have notice pleading in a lot of state courts. So if there's something good for me about the standard of review, I will go and add more detail. So I like to start with a punch. Do something like this. Nevada is a notice pleading state. Boom. Do something like that. The court must liberally construe pleading, blah, blah, blah. But, plaintiffs need only broadly recite the ultimate facts necessary to prove their claims at trial. That gives me a segue into, I love this line, they need not cite the evidence they rely on. Again, you're just reminding the court that we're talking about, a different standard than what you see a lot in federal court. Now, in federal court, technically you don't have to cite your evidence in the complaint. But if you've been practicing for some time, that's not always true. I mean, particularly if you've ever brought a RICO claim, racketeering, you probably have to cite your evidence some of the time. You probably do. Or at least you have to be so specific that everybody knows you have evidence. Okay, you want to make the headings do the work. Everybody skims the headings. So you sit down, the judge might do a couple things. Like one might say, okay, I'm going to read the intro. Or let's say the judge has 30 seconds because they're waiting on, the Keurig, the coffee's coming out. They have the brief in hand. They just read your headings. So if you do all the work in the headings, that connects the pieces for the judge. And the judge can walk away and remember your arguments. So I like to have long headings. Here's an example. So this is a case where the defendant is arguing that the plaintiff should have gotten an expert witness to testify to the exact number of particles of hog fecal matter in the air on the plaintiff's land. Because it's a trespass case. The plaintiffs are alleging that the defendant's factory farms are blowing in all of this fecal matter onto the plaintiff's homes. Okay, so I do the work in the heading here. I say, plaintiffs detect the hog waste by smearing it, seeing it, feeling it wet their clothes, and getting hit by it in the face. And then I deliver the punch. So they don't need an expert to testify that the waste is detectable. Okay, here's another one. Nothing in Ohio law requires, so you can tell, you're rebutting the other guy's argument. Nothing in Ohio law requires a spouse to fill out the artificial insemination consent form to claim that they're a parent. Drop in a dash, make your point. That form is the sole responsibility of the physician. So I like this kind of a structure. You're telling the judge what your argument's about and why. But if you do it like this, there's a side benefit too, which is that you create a beautiful table of contents. Okay? You want your table of contents to be the judge's cheat sheet. Judge is sitting down trying to write an opinion or make a ruling. They should turn to your table of contents and say, okay, well, did the other side address this? Did the other side address this? Did the other side address this? And that's going to help guide them. The more time that the judge spends with your brief, often the better, because you are getting more airtime in front of that judge to convince that judge. Okay, here's an example, table of contents. Put in your key facts. Okay, statement of material facts. Pick a few facts to highlight, but you can see, okay, defendants own 17 of 18 hog farms in the neighborhood. You're highlighting some important facts that you think that the judge ought to know. But you see, you're building out, by doing these longer headings in your table of contents, you are building out just a really nice set of points on a checklist for that judge to go through. And don't be afraid. If you have a case that's a must-read case for the judge, put it in the heading. I know it looks long, it looks awful. I've got one right here, down here. But if you've got one that you think needs to be done, that the judge needs to read that case, just put it in. Because the judge will get the message, oh, I guess I need to read that case. I mean, they put it in a heading. It must be that important. But only do it if the case is really that important. Because otherwise, you sound like you don't know what you're talking about. Okay. when you are in Microsoft Word, okay, you should be automatically generating your table of contents. If you don't know how to do that, you should contact me so that I can tell you how to do that. But just beware of the automatic features. Check your brief before you file, just like check the PDF. You don't want to, the automatic settings in Word, if you haven't changed your default settings, it'll have this like ugly blue font that it'll put in at the top, say table of contents. And then your page numbers, you can get error bookmark not defined. So just be careful about that. And again, if you don't know how to do an automatic table of contents in Word, you should, either I'll do a video on that or you should contact me. Okay, last thing for tonight. Tip number 5, cut bad arguments. Why should you cut your worst arguments? Well, because it's a win-win. The judge wins because your brief gets shorter. And you win because your better argument gets more of the judge's time and it doesn't get diluted by the bad argument. 2 arguments, one argument is good, but 2 arguments are definitely better than 3 because with 3 you have a middle argument. The middle argument, the middle child tends to be neglected. I'm going to give you a heartbreaking example of that for me. This here comes from a case where the other side had moved for arbitration. I was representing a consumer. The other side moves for arbitration. And the problem is we'd already been to arbitration and the other side didn't pay the arbitration fee. So the arbitrators kicked it out. So I filed it in court. The other side comes back and says, but hey, we want to arbitrate again. I raised 3 arguments to the magistrate as to why their motion to compel arbitration should be denied. The first is that I said, hey, look, they breached the contract already by not paying the arbitrators. So if they breached a contract, we no longer have to abide by the contract. So that was argument 1. And it wasn't a bad argument. Point number 2, I said, well, they didn't pay the arbitrator. And the arbitrator said that we could go to court. And the terms of this agreement incorporated the arbitration rules, the rules of the American Arbitration Association, the AAA. Those rules were incorporated into this contract. So I said, look, Judge, you could just follow the contract. And under the terms of the contract, now we can bring this in court. That was a great argument. There was no other precedent on point. So I chose to put the argument second. There really just wasn't a lot of precedent for this. I cited like one state court case, but the situation hadn't come up a lot and a lot of people had just not made this argument. But here's the bad part. I added in a third argument. I said, oh, and the other side waived the right to arbitrate by acting unreasonably, which is the thing that you can do. Well, I raised 3 arguments. What happened? Well, the defendant ignored the middle one on reply. In their reply brief, they just addressed the other 2. They just completely ignored my middle argument. And so the magistrate issued a 7-page decision examining argument 1, examining argument 3, and completely missed, never addressed argument number 2. Never, just didn't do it. So what would have been the result in this case if I hadn't included the third argument, waiver, which is, a weaker argument? Well, it would have been way better, because the magistrate would have been forced to confront the second argument at least. It wouldn't have gotten skipped over. Okay, how do you decide which arguments to drop? This is where your focus groups come in. You got to ask friends, family, colleagues. Think about your case's theme. The more time you spend talking to people about your case and honestly asking them which argument persuades you, the more you're going to know. Okay? And then lastly, if you're only concerned about just not waiving an argument for appeal, just keep it short, put it in the back. The judge will probably skip over it, but that's fine. But your main argument should be getting like 70% of the airtime, and then you really shouldn't have a third argument most of the time. Just do some focus testing and pick your best two. Okay, in the next lecture, we're going to talk about likability, but we're already at 50 minutes, so I'm going to go ahead and stop it. If you have any questions, put them in the comments below. Thanks, guys.